The United States Supreme Court has handed down a massive, unanimous 9-0 decision that fundamentally changes when law enforcement can march right through your front door without a warrant. If you think your home is completely protected, you need to watch out because the Supreme Court delivered a massive warning for current property owners nationwide, and this all involves your protections of your home. In a critical lawsuit, the Supreme Court was forced to confront a dangerous loophole regarding how lower courts evaluate emergency entries into your home. The state courts tried to create a loose framework that would have completely vaporized your privacy protections within your home. The Supreme Court actually stepped in to issue a massive correction, but inside that unanimous ruling is actually a hidden trap that everyday Americans need to be aware of. So we need to break down what exactly the Supreme Court did in this ruling and also some of the concerns and things that you need to watch out for going forward. Now, before we jump into what the Supreme Court did with this ruling, if you like this type of content, make sure you like, subscribe, and turn on the notification bell, turn on all notifications to help to ensure that you never miss any of this information. Now, to understand the impact of what happened in this case, we have to look at kind of the unsettling facts that really triggered this battle in the first place. It all started when police officers in 911 received a report regarding alleged threatening statements made by an individual named Trevor Case. That call was made to 911 by Trevor's ex-girlfriend, and when talking to the police, she actually admitted that she didn't really fully remember exactly what Trevor Case said on the phone to her, but she told the police officers that she had a bad feeling and also warned them that maybe he was dangerous. In response to this, 4 police officers arrived at the home of Trevor Case, and they, obviously knew Mr. Trevor Case. They've had interactions with him in the past. He had a history of some mental health issues, and most of these officers actually knew him. Now, when they arrived at the scene, they looked through his windows, saw nobody inside, but one of the officers actually noticed an empty holster and then also a notepad. Now, here's where things kind of unraveled and created the issues in this case. The police didn't immediately decide to rush into the home. Instead, they stood outside of his home for 40 minutes. Some of the officers openly stated on body cameras that they did not think that Trevor had it in him to do anything wrong, but after about 40 minutes, they discovered that the front door was completely unlocked, and so they decided to enter into the home without a warrant. As officers searched the upstairs bedroom of his home, a closet curtain suddenly jerked open, and then one of the officers claimed that he saw a black object. He then panicked and then opened fire on Trevor Case and hit him in the arm, and I believe that bullet went through his arm and actually hit him in the stomach. Afterward, the police officers searched the home, and in that bedroom, they found a weapon, I believe in a laundry basket that was kind of nearby. Now, in response to this incident, Trevor Case fought back against some of the charges that were brought against him, demanding that this warrantless evidence that was recovered needed to be suppressed under the 4th Amendment. This case eventually made its way all the way to the Montana Supreme Court, who ultimately rejected his arguments in a 4-3 split decision. Now, this shocking escalation proves exactly why you can never assume that your rights will actually be protected on the ground. When federal and state rules are shifting by the day, you cannot leave your personal defense to chance. And that is why you need elite attorneys, elite self-defense attorneys, if you ever have to act in self-defense. And that's why I partner with Attorneys on Retainer. They are a exclusive self-defense law firm that focuses on protecting you if you ever find yourself in a self-defense incident. Unlike typical insurance programs that look for an excuse to drop your case if a high-friction regulation or weird law is involved, unlike these other programs, AOR's program stands by you regardless. So if you want to check out AOR, if you want to look into their program, you can do so using the link down below. And right now, if you use my exclusive code ARMSCHOLAR, you can get $50 off your individual sign-up fee or $25 off the family sign-up fee. Now, when this challenge eventually made its way to the United States Supreme Court, it triggered a massive institutional clash. Mr. Case argued that the 4th Amendment requires strict probable cause before police can execute an emergency aid entry into your home, and he pointed out that the Supreme Court had already struck down some broad community caretaking excuses in landmark cases like Coniglia versus Strom. But here's kind of the wild part with this case. Both the state of Montana and the Trump administration stepped into this fight actively arguing for a much lower standard of review. In fact, the Trump administration explicitly stated and asked for the Supreme Court to approve a sliding scale of reasonable suspicion to give officers broad leeway to bypass warrants and enter your home on these emergency bases. Now, when the final decision of the Supreme Court finally was issued, it was a total 9-0 shutout against that approach by the state of Montana and the Trump administration. The Supreme Court completely rejected the Trump administration and Montana's push for a loose, reasonable suspicion framework, calling it way too weak to protect the home. But the Supreme Court also completely rejected Mr. Case's arguments as well, ruling that the probable cause standard is strictly tied to criminal investigations and doesn't apply to life-saving interventions. Instead, the Supreme Court in this ruling reaffirmed the court's prior standard in a case called Brigham City versus Stewart, which states that police do not need a warrant or probable cause if they have an objectively reasonable basis to believe that an occupant is seriously injured or facing imminent harm. Applying that standard to the facts of this case, the Supreme Court ruled that because the police officers here heard a report that a weapon may be involved, there was concerns from the ex-girlfriend, they saw an empty holster, saw a notepad, and got no response when they arrived at the home, they believed that maybe he had harmed himself or objectively had a reasonable basis to believe that maybe he would. The Supreme Court emphasized that the Fourth Amendment does not require police to stand by and do nothing when a human life is at risk. And so the Supreme Court stated in this opinion that we repeat today what we have held before. An officer may enter a home without a warrant if he has an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. The officer's entry satisfied that test. Accordingly, they stated that we affirm the judgment, even though not all of its reasoning, of the Montana Supreme Court down below. So in essence, the Supreme Court in this ruling upheld the ultimate conclusion of the state of Montana, ruling against Mr. Case, but they rejected the analysis that was used by the Montana Supreme Court to reach that conclusion. Reasonable suspicion was too loose of an analysis, and instead the Supreme Court applies the objectively reasonable test. They also rejected Mr. Case's position that probable cause should be the test used going forward. Instead, the Supreme Court found that that test is too strong and would prevent police from performing necessary life-saving duties. So what is the ultimate conclusion here, and what is the impact of this case? Well, the Supreme Court technically upheld the final judgment against Mr. Case, but they completely threw out and essentially rejected the legal analysis that the Montana Supreme Court used to get there. While they stopped the lower courts from expanding a loose, kind of watered-down caretaker standard, they officially solidified a nationwide rule, which is if a law enforcement officer can point to a credible report involving an objectively reasonable belief, they have the ultimate and potentially federally protected workaround to bypass your front door without a warrant and potentially also go in there. They have a basis to go in there. They don't need probable cause. They don't get the loose standard, but if they have that objectively reasonableness, they can meet that. If they in fact support that, they can enter your home, and that also opens the door to other issues, like in Mr. Trevor Case's situation, the confiscation of the weapon, and also them potentially using that against them in this case. So that is the hidden reality behind that unanimous 9-0 ruling that was issued by the Supreme Court in Case versus Montana. The loose standards were rejected, but the new framework leaves kind of a massive, unprecedented battlefield on your doorstep and potentially also opens it up to these types of exceptions. There's no doubt that there's going to be some massive fallout from this ruling on pending cases across the country, and I will be tracking those closely and bringing those to you if you're interested. So if you want to stay ahead of this and see how this plays out, make sure to hit the like button, subscribe, turn on the notification bells, and so you get updates as I release them. And also let me know in the comment section down below if you think the Supreme Court got this decision correct. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.